necessary. Does reasonable already mean necessary? Is it necessary to use both terms? Who will take this question, please? Secretary for Security. Let me take the first question. The investigation of the offense is being diligently and expeditiously conducted by the police. There is an objective standard. In applying for an order with the magistrate, we will explain why it is taking so long to complete the investigation. There are objective criteria. We will explain the difficulties and why so much time is needed. For example, let's say if there is a task which can be completed in one day and yet is taking a month to complete, then it's impossible to explain that. The LDD can take the next question on point A8. Let me supplement for 6, clause 81 subclause 6. A magistrate has reason to believe, and that means an objective test should be used. And then to answer Reverend Kuhn's question on reasonable and necessary, the first point to consider is all the relevant circumstances of the case, whether under those circumstances, it remains reasonable and necessary to do so. And then to understand the need for extension, we should look at clause 81 bracket 2. That means the circumstances vis-a-vis the application for an extension of the movement restriction orders. These paragraphs should be to be read in such a way. Does it mean that for all the requirements to be imposed, they can restrict certain acts? That's right. Ms. Kamen-Khan. Thank you, Chairman. Subclause 4, the movement registration order is valid for 3 months. What is the consideration? Why not 4, 6 months, but instead 3 months? And then subsection 5, the order must be served personally on the person on bail. So whilst on police bail, this person might have absconded. This person has been put on bail, and then you apply with the magistrate for an order, and yet there is this requirement for personal service. Can you explain that? Let me take the first question, validity of 3 months. We need to strike a balance. We need to strike a balance between safeguarding human rights and the need of the order. It is necessary to apply for an order, so it comes with justifications. And that is one of necessity. And we also consider the change in circumstances. If there is a change, the order may be scrapped immediately. But say if we require a report once a week, it may not be reasonable. And therefore, we need to strike a balance. And we find a period of 3 months appropriate, having considered human rights, resources, and other matters. And then it should be extended by not more than 1 month, because we consider in the first place 3 months to be a long enough period for the order. So if an extension is to be applied for, it should be it should be justified. It should be explained once a month with justifications. For the movement restriction order, it applies to any person who is due to be released or the person on bail. If you take a look at clause 79B, this is what it has been referred to. Normally, for the person due to be released, the movement restriction order can be served personally. For a person on bail, it still should be served personally, because the movement restriction order imposes a major restriction on the person involved. It also involves a criminal offense. So we find personal service a more appropriate way. Chairman. Well, I understand that the administration needs to strike a balance. I just wonder whether this is the best position, since some people may have absconded and they are nowhere to be found. But at the same time, I understand that a movement restriction order will be pointless if they have absconded. I have a question on point 7. There is a mechanism for a person on bail to vary or discharge a movement restriction order. Ex parte application is accepted, but on this occasion, it's for the person on bail to vary or discharge a movement restriction order. If the magistrate refuses to approve the application of the order, there is no mechanism for the prosecution to lodge an appeal. Is that right? That means there is no way a police may file for a review of the application or the magistrate's decision. On the other hand, the person on bail may apply for variation or discharge of the order. No appeal mechanism, is that right? That's correct. But a judicial review is possible. Right. The arrangement is similar to what I asked before. No appeal, but JR is possible. Let me supplement. The person on bail may make an application because we considered, after imposing the restriction on this person, there is a stipulation on showing up at a certain place during certain hours, and that this person may change his job, and there is a need to apply for a change of this order. Mr. Lai Tong Kwok, I'd like to pick up on what Ms. Carmen Khan said. Bracket 4. Is it a blanket time frame for all movement restriction order? Is it 3 months for each and every order? Mr. Wong. Now, bracket 4 refers to a validity period of 3 months, and then subsection 6, the magistrate may extend the validity period of the order, and each period of extension will be 1 month. This can allow for an avenue to extend the order, but the order cannot be shortened, right? It will be valid for 3 months. There are also other conditions. For example, it can be varied or discharged with a change in circumstances. So my next question is this, Chairman. Subsection 4. The validity period must not begin before the date on which the movement restriction order is served. And then subsection 5. The movement restriction order must be served personally. Let's say if this person is detained by the police, there shouldn't be a problem. The order can be served on this person. How about a person who has been released on bail and has left the police station? We don't know when we'll be able to locate this person. So when this magistrate signs a warrant, wouldn't it present a problem? I think it means that it only comes into effect after it's been served. Otherwise, are you suggesting that this person may inadvertently breach the terms of the order without knowledge of what it entails? Yes, it means 3 months after the order has been served for persons not in custody. Mr. Lai Tong Kwok, personal service. I remember a long time ago, there was this case. The law firm applies for a restriction or an injunction order on behalf of a client, and then this law firm staff intercepted this person and served the injunction order on him, and then without taking a look at the order, he just threw it away, and then he tried to abscond. The issue is, without reading the injunction order by the subject, does it constitute service on this person? So Is it that once this order reaches the person, it'll be all right, even if this person decides not to read it and just trash it? Well, I think the word literally means serving the document. It's a matter of, for this person to decide whether to read it or not. Last question, subsection 7. The relevant officer or person on bail may make this application. I don't know whether this is an ex parte application or whether it has been agreed by both parties. Is it that, be it an application made by the police officer or by the person on bail, the application will be made in camera so that both parties may appear before a magistrate for the matter to be dealt with? The answer is in the affirmative. Any follow-up question? Mr. Kitson-Yang. Thank you, Chairman. I have a question on this phrase, each period of extension being 1 month in subclause 6. That means you need to apply for extension every time. Why can't we set the extension period to a maximum of 3 months so as not to waste time? There is already this mechanism under subclause 7. If in the end, it only takes 1 month or so, you can apply for discharge of the order under subclause 7. What is the consideration behind putting in this extension period of 1 month? As we explained, we've given it some thoughts. In theory, investigation work should be completed within a period of 3 months. By this time, no charge has been laid. Upon conclusion of investigation, we can then decide whether to lay charges. Hence, there is no need to for the order to go beyond 3 months. In some circumstances, however, there may be a need to further extend this order. And we've struck a balance between the rights of the suspects and ensuring efficiency of the provision. When it comes to national security cases, we know that police officers really have a lot on their plate. So how about setting a longer period of extension first? And then once the matter has been dealt with, you can apply for discharge of the order under subclause 7. Wouldn't that help the law enforcement agencies in conducting investigation and tying loose ends? Now, for investigation officers, of course, it'd be best if they could be given as long as a year. But still, we need to strike a balance between that and safeguarding human rights. So on this basis, we believe that the reasonable balance should be one of 3 months as a start and then extension of 1 month. I have a question on subclause 3, movement restriction order. We've seen national security cases in which the suspect ultimately absconded. I don't see any requirement for this person not to leave Hong Kong or requiring this person to hand in their passports. Why doesn't this government learn a lesson? Of course, the government must have noticed these cases. You should avoid a repeat of these mishaps. So why can't we just require the suspect to hand in their travel document? As well as in subsection 2 of Article 43 of the Hong Kong National Security Law, there is a requirement for the person involved to surrender the travel document. And if there is a need to impose other restrictions, for example, for this person to make a report at a certain hour at a certain place, or restricting this person from contacting another one, then this can be done via the movement restriction order. Monsieur, I understand that members have shown concern about the travel documents, etc. Now, Article 43 of the Hong Kong NSL provides the implementation rules, and Schedule 2 refers to the movement restriction of the person involved, and a police officer may conduct an ex parte application and require the person to surrender to the police any travel document. Dr. Kennedy Wong. Chairman, the movement restriction order is to be issued by a magistrate. Earlier, I asked about a warrant. I want to know whether a third party will come into knowledge of a movement restriction order. Because otherwise, let's say if I have any contact with this person who is the subject of a movement restriction order, I may be helping this person and hence breaching the law, or at least breaching this movement restriction order. Of course, regard must be given to the policy intent of this order, and that the details may not be disclosed to the public. How do you strike a balance? The order is to be issued in relation to this subject, and because of privacy concerns, it is not reasonable to divulge details to everyone else about the requirements imposed on this person and how and when he should appear where. But as explained, if you know that this person is a subject of a movement restriction order and you continue to help him escape, then you may be committing the offense of aiding and abetting. Mr. Jeffrey Lam. Thank you, Chairman. I thank Secretary and other officials for helping us understand in detail what the provisions are about. Still, this is a bill with a lot of details, not easily understood by the average Joe. Like SYS and other government officials already explained, there are provisions already contained in the Hong Kong NSL. Now, I don't think we are getting long-winded if we include these provisions in the bill as well. At least you should put in a reference to the certain provisions in the Hong Kong NSL for clarity. For example, surrendering travel documents, as we asked just now. I mean, many members already asked many times, is it possible to give a clear stipulation here? Of course, I'm not a law drafting expert. Still, I've been in this council for many years, so I have a bit of knowledge, but even professional lawyers have questions about this. So that's my question. Of course, I'm not a law drafting expert. I think if you just tidy it up, make it easy to understand, it'd be good.
This kind of question has been raised at least on 3 occasions, and the questions have been answered. I'm pressing this question for greater clarity. Who will take the question, please, from the DOJ? Ms. Daphne Siu. To respond to Mr. Lam's questions. In the Safeguarding National Security Bill, there are references to the national security law. The first reference is on the definition of threatening national security. The NSL and the Safeguarding National Security Bill's offenses. When it's an offense against national security, the procedures under the NSL as applicable are set out. Clause 96 contains further details. We haven't got there yet, but if you allow me to get ahead of myself for a moment, Clause 96, it says that for the avoidance of doubt, the offenses set out here are national security offenses under the NSL. And a case mentioned in Article 41 of the NSL is also in connection with the offenses here. There are many offenses under the NSL, and there are enforcement powers. We cannot replicate everything under the NSL in the current bill. Otherwise, we would get a very, very long bill. Mr. Chen Xiu-hong. To write on the question from Dr. Kennedy Wong a moment ago, I take the point from the government. The movement restriction order imposes restrictions on movement for a person on bail. It involves time and place, etc. And there are privacy considerations. So the movement order will not be made public. Dr. Kennedy Wong mentioned a scenario. Someone may unwittingly get in touch with another person subject to such an order. So this is unbeknownst to the person. So the person who gets in touch with the person on bail does not know what they are doing at that moment. But the person on bail knows that it's wrong for anyone to contact them. So the person on bail subject to an order should avoid other people. And if the person on bail gets in touch with other people, the other people should be fine. But the person on bail subject to an order may feign ignorance. So people should not worry about unwittingly getting in touch with a person subject to a movement restriction order. They are fine. Unless they know someone is subject to an order and they get into contact with that person on purpose. Is that correct? Yes. So the bill's provision governs the person on bail rather than the people getting in touch with the person on bail. Chairman, the context is clear, no ambiguity. But some people who don't know the law well, they may worry. Now this is clarified, and I think this restriction makes sense. Thank you, Mr. Chen. So people won't get caught inadvertently when they come into contact with someone subject to an order without knowing it. There is no legal liability for those who unwittingly get into contact with someone subject to an order. Mr. Lai Tong Kwok. The more I read the bill, the more I feel that the drafting team is very cautious. Just to follow up on some questions, subclause 6. For every extension, it will be 1 month in duration. So when you meet 6A and B's conditions, you can apply for an indefinite number of extensions, but each extension will be 1 month. And this can keep going on and on. Is that the case? Yes. Each extension will be 1 month, but there can be indefinite extensions. Now, subclause 7. There can be an application to vary the order. But does this mean that you can only reduce or vary the conditions under such an order? Secretary Bureau. Now, by varying the order, it's about varying the conditions under the order, such as having to be at a certain place at a certain time. Now, on discharging an order, a certain condition may have to be met, a certain condition has to be valid before an order can be discharged, but there should not be a reduction in the order. I don't see a reason when a movement restriction order can be reduced. You can discharge it, but I don't see a reason how an order can be reduced. Chairman, subclause 7. A magistrate has to meet a condition under subclause 8, a very stringent requirement before discharging an order. The magistrate has to be satisfied that this is reasonable and necessary before discharging an order. Just then, Reverend Kuhn raised the same point too. Even when it's reasonable and necessary to do so, there has to be a third condition, and that is discharging the order would not be contrary to the interests of national security. So all three conditions need to be valid, and only then the magistrate can discharge the order. When one condition is missing, the order cannot be discharged. Is that correct? Yes, Mr. Lai is right. So it has to be reasonable, necessary, and not contrary to national security interests. Now, for these restrictions, we are taking a cautious approach. We also have to make sure the rules are effective. If we're too cautious but the rules don't work, then that will undermine the success of the law, and that will be at odds with our purpose. Ms. Carmen Khan speaking for the second round. Thank you. The Secretary mentioned laws that work. Now, I raised a point about serving the order personally. So under clause 79B, when someone is about to be released on bail, you have to serve the order in person. For someone already released on bail or someone who has already jumped bail, how do you locate the person on bail and serve the order personally? If we don't add other forms of service, then we have to find a way to make sure the provision can work. That's a suggestion from Ms. Khan. Any response? I believe in most cases, before the bail starts, the order will be issued and served. Thank you. Please continue to walk us through Clause 82. Review of movement restriction orders, subclause 1. If a magistrate refuses an application made by a person on bail under Section 81, bracket 7, the person on bail, and this is about varying discharging an order. In such a case, the person on bail may make an application to a judge of the court of first instance for the first mentioned application to be granted. So this is the review application. Subclause 2. The judge of the court of first instance must not grant a review application unless the judge is satisfied that in all the circumstances of the case it is reasonable and necessary and would not be contrary to the interests of national security to do so. So the considerations are similar to those under Clause 81, subclause 8. Clause 82, subclause 3. The judge of the court of first instance may by order confirm, vary, or revoke the magistrate's decision and may make any other order in relation to relevant matters as the judge of the court of first instance considers just. Thank you. Dr. Kennedy Wong. Thank you, Chairman. A question for the government. Clause 82. This is about a review application. This is a review, but not a judicial review. For this review application, the magistrate refuses to issue an order. So the matter goes to the CFI for the first review. If the applicant is not happy about the outcome, will that affect the applicant's right to judicial review? DOJ, please. Thank you. Now, this review application involves the CFI. The CFI cannot be subject to a judicial review. You cannot have a CFI, you cannot have a judicial review where the CFI is the subject. The CFI can review the movement restriction order with a wider scope than in a judicial review, because in a JR you have to look at the procedural propriety and legality. Subclause 2 here, the CFI judge will look at all the circumstances of the case to determine whether the application is reasonable and necessary. So the applicant has to choose either the option in subclause 2 or a judicial review. Is that the case? In general, a magistrate may deny a bail application. Here, there is already a review mechanism, so there is an alternative revenue. In that case, the applicant should not turn to JR. The applicant should instead go for the option under subclause 2. But this is not an appeal mechanism. This is a review mechanism. Indeed, Chairman, just to follow up. So the person on bail looks at the CFI's decision. The person has further avenues for appeal. Is that the case, Mr. Ivan Leung? On the appeal, this depends on the regulations under the High Court Ordinance. For the movement restriction order, when the CFI denies the review, there is no further appeal. In a criminal case, charges are pressed, the defendant is denied bail, the registrar denies bail. The applicant goes to the CFI for bail, and then the CFI denies the bail again. The defendant cannot appeal further. There are CFA cases stating why. For the bail system, the defendant can go to the magistrate or the CFA again over the bail, over varying or discharging the movement restriction order. So we will not put in place an appeal mechanism. Now, even when there's a failure at the CFI for a review, if there's a change in circumstances, the applicant can go to the CFI again with a fresh application. Mr. Lai Tong Kwok. To write on Dr. Kennedy Wong's question, Clause 82, the CFI makes a decision. I don't have the time to go through the High Court Ordinance, but my impression is that the CFI decision should be subject to an appeal. It doesn't make sense if there's no appeal. There were legal actions over whether an appeal can be lodged. So to play safe, can the government look at this provision again to see if an appeal is impossible? Now, my question has to do with subclause 3 under clause 81. The judge of the court of first instance may, by order, confirm or vary. I know what confirm means, revoke is clear enough, but vary is the question. What can the judge vary? The magistrate presumably has denied the application, so what is there for the CFI judge to vary? In what circumstances will we see a CFI judge vary something in a case? Just an example, say there's a condition saying that the person on bail has to be somewhere at a certain time. Say this person on bail has changed a job with different work hours. So the applicant can ask for a change in the time, but the magistrate may be not satisfied and may deny the application for varying the hours. The DOJ can elaborate on this point. I fully agree with this S4S. There are conditions attached to the movement restriction order. Clause 80, subclause 2, there are conditions. They can be varied. Time, place, people, etc. Those conditions can be changed. So by vary here, we're talking about varying those conditions. Chairman, to write on the S4F's example, the magistrate may refuse to vary those conditions, and then the CFI judge may decide to vary the conditions. So isn't that a case where the CFI judge discharges the order? Or are you talking about varying the conditions being applied for? You're either varying the conditions or discharging the entire order. When I say vary, you are varying the conditions in a movement restriction order, Secretary for Justice. Now, this is about review. This is a de novo hearing. You are considering the matter from afresh. This is different from appeal. To appeal, you have to prove that something has gone wrong at the lower court. The review application here is to give the CFI the full powers to reconsider the case. A review can involve affirm, vary, rescind, or discharging a decision. So here, the CFI has the full powers to consider the matter afresh. The CFI can confirm or reject the decision. And then in between, the CFI judge can consider what to do as well. So it depends on the legal basis for the review. To write on Mr. Lai's point, can you look at this provision again and get back to us? Clause 83. Thank you. Contravention of movement restriction orders. If a person on bail without reasonable excuse contravenes any requirement in a movement restriction order made in relation to the person, or B, any condition imposed in relation to the requirement, the person commits an offense and is liable on conviction on the indictment to imprisonment for 1 year. Thank you, Chairman. Mr. Tony Tse. This is about someone breaching the order. On conviction, 1 year in prison. Clause 81 is on granting the order. Subclause 2 under Clause 81. Breaching the order sounds serious. This may endanger national security. Why just a 1 year jail term? I think 1 year sounds lenient. So why set this jail term? Security Bureau. The movement restriction order is a specific tool. A breach of this order will give rise to a limited impact. We looked at similar provisions elsewhere. We looked at the penalties for breaching other similar tools. The penalty here is broadly similar to those conditions.
Chair, when a magistrate makes a decision, they may consider the circumstances, and I think the impact can be quite serious as it may endanger national security. I feel that the imprisonment term is not so proportionate. Why would the administration consider the breach to be minor? Security Bureau. Overall speaking, because it is not an act to endanger national security. It's not like other offenses such as treason. It is just a contravention of a movement restriction order. And let me remind you that the investigation should be ongoing. So this is in addition to the case concerned. Chair, I think the same way the maximum imprisonment term for the contravention of movement restriction orders is 1 year, but then there are many restrictions imposed. I think, of course, it is important to impose the restrictions. And in the bigger picture, I think, as other members said, this is minor, but then it is still quite serious. Would the administration consider making the punishment more severe? Thank you, Chair. As I said earlier, as the investigation is ongoing, there may be other forms of punishment to be imposed. And if other offenses relating to the endangering of national security is identified, they will be punished for such offenses as well during the 1 year. Dr. Lo Wai Kwok. Thank you, Chair. We talked about how to implement the movement restriction orders as well as what to do during the contravention of movement restriction orders. In order to make sure the person on bail not to interfere with the investigation, especially with them leaving Hong Kong without leave. It is important to ensure that their travel documents are surrendered so as to prevent them from absconding. As other members said, I think the clear wording should be more clear, even though it may have already been stipulated in national security law. I just think it's better to make things clear rather than leaving it up in the air. Thank you. It's a suggestion. Mr. Lai Chong-kwok. As Mr. Chen Siu-hong said, I have doubts about the degree of the imprisonment term. This is on indictment, and offenses on indictment should be more serious in nature. If we take this perspective, a 1 year prison term may be a bit too lenient, but I do respect the views of the administration. Also, can the administration tell us that for the punishment of bail conditions, what would that be? Can some examples be given? Thank you, Mr. Lang. Thank you, Chair. Thank you, Mr. Lai, for your questions. Members can draw reference to Chapter 221 Criminal Procedure Ordinance in Section 9L. It relates to absconding without leave from the court. The penalties are that if convicted on indictment, it would be a 12-month imprisonment. So it is in line with what we have here. As for the venue of trial, it may be an indictment offense, but we also have to consider what is said in the magistrates' court's ordinance. Magistrates' courts can make use of summary proceedings to deal with indictable offenses. It's just that there are some accepted offenses in the schedule of the ordinance. Thank you, Chair. Let's proceed. We have now the subdivision 4, miscellaneous provisions and offenses in connection with investigation. Thank you, Chair. Clause 84 relates to applications under this division to be heard in closed court in general. So Clause 1, an application under this division must be heard in a closed court. And this division refers to any applications relating to the detention period as well as the consultation with a lawyer. So Clause 2, the judge of the court of first instance or the magistrate as applicable hearing the application may either on his or her own motion or on application by any party to the hearing order the application to be heard in open court. So Clause 3, however, the judge of the court of first instance or the magistrate may only make an order under subsection 2 on being satisfied that doing so is necessary in the interests of justice and would not be contrary to the interests of national security. Thank you, Chair. Reverend Peter Kuhn. Thank you, Chair. I want to ask about it being of justice. It may be talking about this as a layman, but here it says that an application must be heard in a closed court, but for the interest of justice, and it would not be contrary to the interests of national security, the judge of the court of first instance or the magistrate may only make an order to be heard for the application to be heard in open court. Will that sound unfair to people's views? In terms of procedure, for the defendant or any stakeholders, whether it is fair, whether it is fair in justice. Reverend Peter Kuhn talked about hearings that may be held in open court, and most of them are indeed. But in some cases, when it may be unfair to parties, hearings may be conducted in a closed court. Thank you, Chair. The next one to ask questions would be Mrs. Regina Ip. Thank you, Chair. I have a minor question about the wording. In Clause 84, it mentions the judge and that they're on his or her own motion and so on. But then in Chapter 1, they would just use their own. Why didn't they follow the convention? It may just be 2 additional words, but then you often say that we should follow conventions. Why aren't you following the convention on this occasion? Law Drafting Division. Thank you, Mrs. Ip, for your question. As said by Mrs. Ip, there is such principles set out in Chapter 1 indeed, but the Law Drafting Division has adopted in recent years a gender-neutral approach. And this is the approach that we have adopted in other ordinances as well. Thank you. Next to speak, Mr. Holden Chow. Thank you, Chair. I also have a suggestion to make. In closed court cases, non-national security cases in other jurisdictions, I understand that, for example, the National Security Act 2023 provides that certain cases will be heard in a closed court. I believe the concern is that it may involve sensitive data, and if such data is published in court, it may endanger national security. So it's just my comment here that I want to let the public know that I think a balance is being struck here. When cases are heard in a closed court, there may be concerns of the administration when they make such decision. Mr. Leung, thank you, Mr. Chow, for his comments. In fact, it's not just in national security cases. In non-national security cases, at the investigation stage, a lot of the hearings will be held in closed court. For example, a production order made under Chapter 455 would be made in a closed court. The reasons for which I've mentioned before, because if the hearing is held in an open court, some information about the investigation may be leaked, thus compromising the investigation. In other cases, it may be because if such information is discussed, it may jeopardize the case, the fairness of the case in particular. For bail proceedings, we would often have a restriction on reporting. But in the interest of fairness, the judge may lift the restriction. Mr. Chan Soo-hong. Thank you, Chair. In 84 brackets 2, if the defendant applies for the hearing to be heard in open court and the judge or the magistrate, if they are satisfied that doing so is necessary in the interests of justice and would not be contrary to the interests of national security, may make such order. Can an appeal be lodged, however, by the Department of Justice? As the Department of Justice is a party to the proceedings, they will provide justifications during the proceedings. But it is said that the Court of First Instance can conduct a hearing de novo. Is it possible that they will have the power to do more? Sorry, I got Mr. Chan's question wrong. Indeed, if the Court of First Instance has discharged the decision or denied the decision, there is no appeal mechanism. Mr. Lai Tong-kwok speaking for the first round. Thank you, Chair. I note that in subclause 3, it says that the judge must be satisfied that doing so is necessary in the interests of justice and would not be contrary to the interests of national security. But I can see that when we discuss 81 brackets 8, it is that the magistrate must be satisfied in all circumstances of the case it is reasonable and necessary and would not be contrary to the interests of national security. I do see a few words missing here when comparing the two. Why are the other words not added here? Thank you, Chair. For decisions made by authorities empowered by law, the decisions would have to be reasonable, so it does not have to be spelled out. But in that case, then you wouldn't have to mention it in 81. I believe the wording would depend on the context. When we say necessary in the interests of justice, it is applicable in this context. We have to look at the subject matter. We have to see whether the words are necessary in this context. I understand the viewpoint of the administration. Any follow-up from Mr. Lai? No, thank you. All right, let's proceed with Clause 85. Thank you, Chair. Clause 85 relates to no prejudicing of investigation of offenses endangering national security. This is a new offense. If a person knows or suspects that an investigation of an offense endangering national security is being conducted, A, the person, 1, with intent to prejudice the investigation, or 2, being reckless as to whether the investigation will be prejudiced without reasonable excuse or lawful authority makes any disclosure, or the person, 1, knowing or suspecting that any material is likely to be relevant to the investigation, and 2, with intent to conceal the facts disclosed by the material from persons conducting the investigation without reasonable excuse, falsifies, conceals, destroys, or otherwise disposes of the material, or causes or permits the material to be falsified, concealed, destroyed, or otherwise disposed of. The person commits an offense and is liable on conviction on indictment to imprisonment for 7 years. Thank you, Chair. Mrs. Regina Ip. Thank you, Chair. This sounds like a serious offense. The penalties are a 7-year imprisonment term. How does this compare with the penalties for obstruction of justice? Who's going to answer this question? Well, I think we can compare this to the Article Ordinance. The penalty is comparable. It is also a 7-year prison term. Anything to add? Nothing. Thank you, Chair. Ms. Carmen Khan. Thank you, Chair. I want to ask about, it says here in Clause 85, if person knows or suspects. I believe this comes from Division 1. With the movement restriction order, it would include someone residing in the same place. So for this clause, if someone residing with this person destroys evidence or do any other acts mentioned in this clause, the maximum prison term would be 7 years. I just want to make clear whether the person residing with the person in this case would be punished in the same way. The subject matter would be that any person, so it would be anyone.
In terms of severity, is there any difference between A and B? Because the penalty clause comes after the descriptions in A and B. For the person making the disclosure, or the person disposes of the material, or falsifying, concealing, destroying the materials, is there any difference? Sentencing depends on the facts of the case. I'm sure the court will do so accordingly. Mr. Jeffrey Lam. Thank you, Chairman. Of course, by materials, we're talking about all materials, including what is material to the case. So this person disposes of the material or causes the material to be falsified, etc., etc. Now, will this person be in breach of the offense of perverting the course of justice? Will this be an additional charge? Say after a computer or some files in the electronic form have been taken away, and then upon investigation they are found to be not relevant to the case and not relevant to any national security offense, and yet this person has committed acts such as disposal of the material or causes or permits the material to be falsified, concealed, destroyed, etc., then will this person be contravening the law? Ms. Siu. Well, in previous meetings, we already covered the principles. If an act constitutes more than one offense, then we will go by the DOJ's prosecution guidelines. Now, for the offense of perverting the course of justice, this is a common law offense. So on top of what is set out here, if the elements of this common law offense can be made out, then there could be another charge. And for the common law offense, there is no penalty provision. In 101I of the Criminal Procedure Ordinance, it provides that this person may be sentenced to any term of imprisonment or fine subject to the court's discretion. So regardless of whether the materials relate to the case itself, the act could constitute one of perverting the course of justice. Yes, Mr. Holden Chow. Just a point of confirmation. Under this proposed new offense, there'll be full legal professional privilege. Is that right? So what follows is that if a lawyer takes on a case in the form of being the litigating party or giving legal advice, then of course I understand that the LPP still applies and that all information disclosed will be subject to LPP. What happens is, in this scenario, when a lawyer receives certain information, the lawyer is of course responsible for protecting the information. But what if the lawyer is reckless? If the information is mistakenly disclosed due to recklessness, then what is the position of LPP? Thank you. DS. As explained by the SJ this morning, everyone, including lawyers, should share this common responsibility when handling NS cases. The materials should be kept confidential. At the moment, there are lawyers handling national security cases. After passage of the bill, when there are new offenses, I'm sure that the same requirement would be rigorously observed by lawyers. To answer your other question on the position of LPP, this offense does not in any way overturn the legal professional privilege. Dr. Kennedy Wong. Clause 85, no prejudicing of investigation of offenses endangering national security. A1, with intent to prejudice the investigation. Does it include misleading the investigation with intent? this is a broad description, and I believe that willfully misleading an investigation may be captured by this provision. Reverend Peter Kuhn. 85B1. There is a reference to the word material. So my question is whether the same word material is used in different provisions. And then next bullet point, with intent to conceal the facts disclosed by the material from persons, so on and so forth. I'd like the administration to explain what this means. Yes, I have the same question. There are similar descriptions in another provision: facts, materials, documents, etc. Can you explain the difference? Yes, Chairman. Now, for the provisions that I have come across, material refers to the information obtained through investigation. So that's the term commonly used. Dr. Kennedy Wong, can you repeat the second? Reverend Kuhn, can you repeat the second question? Conceal the facts disclosed by the material. Can you explain this phrase to me? Thank you, Chairman. I reckon this refers to this situation. There may be different sets of materials, and yet there is a very important part that is being concealed. And because of that, because of the concealment, the facts on reading this material could mean something entirely different. A follow-up question, Chairman. Because it says with intent to prejudice the investigation, do you need to prove the actual act? No, intention will do. SJ, let me illustrate by this example. Let's say if I have this letter with me from a suspect of an NS case. Now, in this letter, there is a bank account number which could help us trace the whereabouts of the funds related to an NS case. Now, I want to conceal this from others. I don't want anyone to know this bank account number. I may just burn this letter, or I may obliterate this letter. I cover the bank account number so that I conceal the fact, and this piece of fact is the bank account number. The act itself is to dispose of the material or to falsify, conceal, destroy this material so that the facts relating to the investigation of this case will not come out. Clear? Yes, Chairman. Please continue. We're now at Division 2, absconders charged with offenses endangering national security, and then Subdivision 1, specification of relevant absconders. Sorry, Chairman. May I refer you to the amendments? Is that Cap 143 about the police force ordinance, page 181 of the bundle? Clause 143, Section 3 of the police force ordinance. Section 3 to be amended about the definition of serious arrestable offense so that it covers an offense endangering national security, to clearly stipulate that the police can invoke the powers under the provisions of serious arrestable offense The details can be found in paragraph 68 of the electrical brief. That's page 182 of the bundle. Members can refer to 182, page 182, about serious arrestable offenses, including an offense endangering national security, and that this serious arrestable offense provision will be repealed. No other questions? Right. Let's turn to the next amendment. Clause 148. It starts at page 234 of the English version. Clauses 148 to 152, amending sections 17, 17A, 17 capital B, 17BA, and 17BB of the Customs and Excise Service Ordinance. So for the law enforcement officer, they can rely on the powers of arrest and search, etc., in section 17 and the subsequent sections. As you can see, there is an addition of an offense endangering national security. So that's clause 148 all the way to clause 152. I'll give members some time to read it through. Ms. Carmen Khan. Chairman. Clause 147 of the Blue Bill, section 48 of Trade Unions Ordinance to be amended. Here, there is an addition, or any offense endangering national security. That's all right, but I see that the following is deleted. Sedition or any offense against the state or the sovereign. Are you looking at clause 147? That's page 233 of the English marked up. We're looking at clauses 148 to 152 now. All the way to 151, no, 152. You just referred to clause 147 of page 189 of the Chinese version. Oh, sorry. Let's go back to the administration. Please walk us through the next one. Division 2, absconders charged with offenses endangering national security. Subdivision 1, specification of relevant absconders. Clause 86. Thank you, Chairman. Power of Secretary for Security to specify an absconder for application of certain measures against the absconder. Subclause 1. If the Secretary for Security reasonably believes that it is necessary for safeguarding national security to specify a person to which this subsection applies for the purposes of subsection 4, the Secretary for Security may, by notice published in the Gazette, specify the person for the purposes of that subsection. So that means the Secretary may specify this person as an absconder. And then subsection 1 applies to a person if a magistrate has, in case in which the person is charged with an offense endangering national security, issued a warrant to arrest the person. And then B, reasonable steps have been taken to inform the person of the issue of the warrant, or the Secretary for Security reasonably believes that the person knew of the issue of the warrant. Then C, this is the third condition. A period of 6 months after the issue of the warrant has expired. D. The person has not been brought before a magistrate. And E. The Secretary for Security reasonably believes that the person is not in the HKSAR, subject to meeting all the conditions. Subsection 1 applies to this person. And then subsection 3, the Secretary for Security must revoke a specification made in relation to a person under the following conditions. That's about revoking a warrant. As per A, the warrant in respect of the person has been revoked, and B, the person has been brought before a magistrate. Subsection 4, if the Secretary for Security specifies a person under subsection 1, he may, during the period within which the specification is in force, that means after the Secretary for Security has specified this person as an absconder, and whilst this specification is in force, he can publish a notice in the Gazette and further specify that the Secretary for Security reasonably considers to be suitable in all the circumstances of the case apply in relation to the person, and that one or more provisions should apply. That means the Secretary for Security may further specify the provisions in subdivision 2 of this division. We'll come to that later. The Secretary for Security may, by notice published in the Gazette, vary or revoke a specification made under subsection 4, and then the next one refers to the further specifications. Ms. Carmen Can. Ms. Khan. Thank you, Chair. The administration just walked us through Clause 86, Subclause 2, and there are 5 conditions to be met, one of which is this. At the lapse of 6 months after issue of the warrant by the magistrate, if the person has not been brought before a magistrate and the Secretary for Security reasonably believes that this person is not in the HKSAR, so on and so forth. I have a feeling about this time frame of 6 months. That is to say, we can make an inference that this person has absconded. My question is, the purpose of having a subdivision here, is it for those who have absconded and evaded liability, and that these persons will be compelled to come back to Hong Kong, and there is no way out for them, they should come back to Hong Kong and face justice? I want to know whether this is a concept of inference. How do you decide whether it should be 6 months or 3 months?
As for us, we set it at 6 months based on an assessment. First, the legislative intent. The NSL is about prevention. We have the provisions there to create consequences for absconders, such as revoking the passport and taking away other things. We don't want people to abscond so that they face justice. Now, for absconders, we want to show them there are consequences for absconding. Absconding isn't the end of the story. And we will get into the specifics in a moment. So to achieve that end, we need to make sure that we're targeting absconders. So after the warrant is issued, that's the first step. We have to give it reasonable time. The person needs to be informed that the warrant has been issued, and then we have to decide whether this person comes back to face justice. if this person has yet to show up after 6 months, it will be very unlikely that this person will come back to face the consequences. So then, at that point, we will have to take measures. Chairman. Why 6 months? Bracket D reads that the absconder has not been brought before a magistrate. Could it be something wrong with the judicial system that's causing delay? How can we tell it's not caused by something in the judicial system? We have to make sure every condition is valid, and then the S4S reasonably believes the person is not in HKSAR. Security Bureau, please. Mr. Ivan Leung. Thank you. Item D. The person has not been brought before a magistrate. This is about an arrest. The warrant says that once this person is arrested, the person needs to be brought before a magistrate. So item D means the arrest has not taken place yet. Ms. Khan wondered whether there should be reasonable effort in tracking down the absconder. Item B. Reasonable steps have been taken to inform the person of the issue of the warrant. And then 6 months has lapsed, and the S4S believes this person is not in the HKSAR. So that's all the criteria needed for determining this person has absconded. This person has no desire to come back to Hong Kong. Thank you. All clear. Mr. Holden Chow. Thank you. My question is about the 6 months. Just then, the S4S has explained this. So the 6 months is a window for this person to come back. But let me take a different approach. From what we can observe, many absconders, once they're out of Hong Kong, they issue all kinds of brazen remarks. They go open, they go public about absconding, and that's very undesirable. So based on that, you should be able to tell that such absconders are very unlikely to return. So here's my question. So all these conditions need to be met before the S4S can take action. The 6 month window is an opportunity. Can we draft it differently? Can we draft it in such a way that the government has control instead? Say you know already the absconder has no desire to return. The absconder may have made all kinds of brazen remarks. And in those cases, we don't even need the 6 month condition. The warrant has been issued, the person has fled, we know the person is no longer in Hong Kong. Why not fast track the process? Because there are subsequent measures to be taken. We have to stop money from reaching those people. So let's let the government have control over the process. Secretary for Security. The legislative intent is that we need to have all these conditions to be met. We want to give the opportunity for the person to turn themselves in before waiting for money to be cut off and having their qualifications to be stripped. The best is for the person to come back. Ms. Daphne Seal. Just to supplement the S4F's remark, we would do risk assessment when we also looked at the organized and serious crimes ordinance. Schedule 3, item 9 under the national security law says that for absconders, 6 months after the absconder fails to show up, the government can apply to the court for an order to to seize the property of the absconder. So that's in the NSL, and then we also do risk assessment. Chairman, the government has cleared up the concept, but I have this idea. You give the person so much time and you know this person isn't coming back, there are subsequent measures to be taken. The more time you give the person, the more time this person has to do whatever they want. This will mean more time for the person to endanger national security. Just my thought. I believe the government has noted your comment. Mrs. Regina Ip. I echo the remarks from Mr. Holden Chow. You specified someone as an absconder, and you have to meet all those conditions under Clause 86, Subclause 2. Why be so rigid about the 6-month window? The moment someone absconds, they badmouth Hong Kong, they take part in anti-China activities. You can see that on TV. You know this person has fled. You're assuming that you spend time searching for the person, but then in reality, you see people engaging in undesirable activities almost as soon as they abscond. So, can we have a streamlined approach to dealing with those cases? Can the government consider the suggestions from members? Dr. Kennedy Wong. I looked at the 5 conditions under subclause 2. One thing leaves me puzzled. It reads, the Secretary for Security reasonably believes that the person is not in the HKSAR. Why do we need this condition? There were non-national security cases. The absconders in those cases breached the warrant from the magistrate. The government could take certain measures. The measures may not be as clear as those set out in this bill, such as revoking the passport, Hong Kong ID card, and stripping them of professional qualifications, etc. But this person has already breached the warrant. Why wait till this person flees Hong Kong? This person may have gone into hiding in Hong Kong. Why do we need this requirement about the reasonable belief that this person is no longer in the city? Deputy Secretary, the concept behind these conditions is that actions will be taken after we believe a person has fled Hong Kong. If these people are still in Hong Kong and we take those measures will have a major impact on those people. So out of fairness, we will do our fact check. We make sure this person is out of town, and only then we take the subsequent measures that would be fair and prudent. Ms. Carmen Khan, speaking for the second round. Our discussion clarifies the matter. The measures here are reasonable to everyone. We don't want to just assume someone has fled after 6 months. We give the person 6 months time. 6 months after the warrant is issued and this person does not show up, then the name of this person shows up in the Gazette, and then there will be consequences in the form of a series of measures. So Gazetto is part of the process. Are there subsequent steps? Are there steps involving the court later on down the road? Chairman, this will be an administrative procedure. These steps are taken by the administrative bodies. The government already has the power to take the steps. In such a scenario, we believe these are the reasonable steps for the government to take, and we are being fair to the people involved. We suspend the licenses of the person involved. We don't just strip the person of everything they have. We want these people to come back to face a fair trial. Once the person comes back and stands trial, our measures will be revoked. Next, Mr. Lai Tongkwok. Thank you, Chairman. On item C, I agree with other members who have spoken. The 6 months is unnecessary. Once the other conditions are met, at any time, the Secretary for Security can make the specification. The S4S can choose to issue the specification at the end of the 6-month mark or earlier. So why tie our own hands at this point? Condition B, reasonable steps have been taken to inform the person of the warrant, and the S4S reasonably believes the person knew of the issue of the warrant. Everything else has been taken. Why tie the hands of the government? So I invite the government to reconsider this. Let's cross out condition C, and we don't have to worry about the length of time after the issue of the warrant. Now, my question has to do with subclause 4. The S4S specifies a person in the Gazette. We read on, we can tell that there will be certain things that other people cannot do once the name of the absconder shows up in the Gazette. So you take the steps, the Gazette happens. Can we tell for sure everyone else will be aware of it? Say you don't allow other people to send money to an absconder's bank account, or you ban the absconder from buying stocks in Hong Kong. There are industry practitioners and institutions. How do the practitioners and the institutions know about the absconder's details? Are there administrative mechanisms to alert all those institutions, companies, and personnel about the absconder's details? Otherwise, you put something out through the Gazette, and then the institutions and practitioners know nothing about that, and there will be no impact on the absconder. Security Bureau, I agree with Mr. Lai. Gazetto is the basic step we will take. When financial institutions are involved, we will let them know so that they know what to do about the absconders. So there will be a procedure that we will stick to. Mr. Tony Tse. Many members have spoken on the 6-month requirement. Members wonder the impact of the 6-month window on absconders. What will the 6-month window do? Will the people just come back after 6 months? We need to consider those factors before setting the limit at 6 months. Why tie our own hands? If the 6 months window does not work, then the provision simply does not work, or you have a provision that undermines the law. Let's look at the other requirements. There is a warrant. The government can reasonably believe this person has absconded. Why wait 6 months? Security Bureau. We explained the rationale for the 6 months. But we note members' comments. We will revisit this point again. Mr. Gary Chen. I've been following member speeches. Can we switch on Mr. Gary Chen's microphone? Chairman, I've been following members' comments on the 6 months window. I agree. This is tying our own hands. I'm not sure this is right. Our officials are very lenient. Officials want to give people another chance. But these people involved, they undermine national security. They're worse than murderers. These people want to abscond. Why would they want to come back? Even if they say they will come back, we shouldn't believe them. Those people are hypocrites. So I invite the Secretary for Security to revisit this point. Either we shorten the 6 month window or we leave out the 6 month window. That way we can streamline law enforcement and then we can go ahead to take measures to restrict what those absconders can do. So I invite the government not to get unduly generous with the requirements. Dr. Lo Wai Kwok. Now, I may be raising a point already addressed. There are follow-up actions to be taken for absconders. Absconders have to face legal consequences. So there should be measures in place to prevent absconding, and they have to do with travel documents. And we need these different measures to go hand in hand. That's a suggestion from Dr. Lo Wai Kwok. We note the members' comments. Mr. Chen Xiuhong. Members have commented on different aspects. During our scrutiny, we can tell the government has made reference to national security laws overseas, and then we have drafted a bill suitable for Hong Kong. We have struck a balance in many aspects. Penalties are relatively moderate. Law enforcement shows great restraint, but we should be stringent where warranted. I have concern about Condition C, a period of 6 months after the issue of the warrant has expired. My worry is that we may be sending the wrong signal. Endangering national security, it's a grave offense. The highest jail term is life imprisonment. Someone deliberately absconds. We should not tie our hands. We should not be unduly generous. I worry that we may be sending the wrong signal. So I echo other members' thoughts. I invite the government to rethink this condition. Otherwise, we send the wrong signal. If we are being unduly generous, we cannot achieve our goal of achieving deterrence. Any response?
Secretary, we understand that members want us to reconsider, and we will do so. Thank you. Reverend Peter Kuhn. I think the same way. I may be a pastor, but I guess the administration has more mercy than I do. When we looked at the bill, we can see that there are many provisions that would account for many possibilities. If Secretary wishes to give mercy, they can do so at other stages. We do want the administration to take more of an initiative and perhaps remove the 6-month requirement. Thank you. You do note Reverend Kuhn's suggestions. Yes, as the pastor would say it, we will definitely note his suggestion. If there are no other questions, we'll move on to subdivision 2, measures that may apply against relevant absconders, clause 87. Thank you, Chair. Clause 87 relates to prohibition against making available funds, etc., or dealing with funds, etc. Subclause 1, it is specified under section 86 brackets 4, including by virtue of section 86 brackets 5. If it is the case that this section would apply in relation to a person, the person is a relevant absconder for the purposes of this section during the period within which the specification is in force. Subclause 2. Except under the authority of a license granted under section 94, a person must not A and B. Well, I will go into the details in relation to the licenses in later clauses, but let me come back to this. A, it would be make available directly or indirectly any funds or other financial assets or economic resources to or for the benefit of a relevant absconder, or B, deal with, and deal with would have a definition later on, and the rest is the same as A. Directly or indirectly, any funds or other financial assets or economic resources belonging to or owned or controlled by a relevant absconder. Subclause 3, a person who contravenes the subsection above commits an offense and is liable to imprisonment for 7 years upon conviction. 4, it is a defense for a person charged with an offense under subsection 3 to establish that the person did not know and had no reason to believe A, for a contravention of subsection 2A, that the funds or other financial assets or economic resources concerned were to be made available to or for the benefit of a relevant absconder, or B, for a contravention of subsection 2B, that the person was dealing with the funds or financial assets or economic resources belonging to or owned or controlled by a relevant absconder. Subclause 5. As we mentioned defenses before, we have the clause about proof of burden here. A person is taken to have established a matter that needs to be established for a defense under subsection 4 if A, there is sufficient evidence to raise an issue with respect to that matter, and B, the contrary is not proved by the prosecution beyond reasonable doubt. Subclause 6. A person is not to be regarded as having contravened subsection 2 by reason only of having credited any of the following to an account belonging to or directly or indirectly owned or controlled by a relevant absconder: A, interest or other earnings due on that account; B, payment due under contracts, agreements, or obligations that arose before the date on which the relevant absconder became a relevant absconder. Subclause 7. There are some definitions on deal with. For example, there are parts A and B in respect of funds and in respect of other financial assets or economic resources. There are 3 points to funds. 1, use, alter, move, allow access to, or transfer. 2, deal with in any other way that would result in any change in, as said in 1. Those would be the other ways that are to be dealt with in 2. that would result in any change in volume, amount, location, ownership, possession, character, or destination, or 3, make any other change that would enable use, including portfolio management. And B, in respect of other financial assets or economic resources, it would be used to obtain funds, goods, or services in any way, including by selling, hiring out, or mortgaging the assets or resources. Next, the definition of economic resources. There was a similar definition before, and it is repeated here. It means assets of every kind, whether tangible or intangible, movable or immovable, which are not funds but can be used to obtain funds, goods, or services. There's also a definition for funds. It includes parts A to H. I will not read them out one by one. Members, please refer to the parts. Thank you. Thank you. I think clause 87 is very important. I think we're close to 4:30 now. Let's take a break. And then we'll come back at 4:40. And then we'll resume our scrutiny then. Thank you. Oh, excuse me. Let's move on to agenda item 2, AOB. There's no other business. Meeting adjourned. Thank you.